Great. Hi, everyone. Thanks so much for joining us for our webinar today. It feels like it's been ages since we've done a webinar, so I'm very excited about this one that we're doing today. We've got here Willie Roos, the CEO of Stratafin, and we've got Dilen Heerschop, who's associate at DTB Attorneys. And today they will be discussing building and sustaining a compliance champion program in the community schemes industry. So this was actually a topic that Willie spoke about at NAMA. So he will be discussing it again on obviously a larger platform, which is this webinar, so that more people can have access to it. So let me just introduce our speakers. So Willie has practiced as a property attorney for over 20 years. He's been involved in sectional title management for over 8 years, where he's dealt with various municipal deals and interacted extensively with local municipalities. He started Stratafin in 2014 with the goal of assisting body corporates with their funding without catching them at a debt trap, and Stratafin strives to be a fair and equitable money provider for the sectional title industry. And Dilen Heerschop is a legal practitioner of the High Court, specializes in the law pertaining to community schemes and the concomitant compliance issues faced by community schemes. He has conducted various seminars for the National Association of Managing Agents on compliance aspects relating to the Property Practitioners Act. He obtained his LLB degree with distinction and thereafter completed his LLM in estate law. Dilen has joined DTB Attorneys as a community scheme specialist attorney, and DTB Attorneys is a Stratafin preferred service provider and panel attorney. So Dilen has a lot of information on compliance. So I'm going to hand over to Willie to start the conversation.
With me today, as Cara said, is Dilen Heerschop. So Dilen is one of the rising stars in the sectional title industry and law industry, and we're happy to have Dilen with us and chat about compliance with us today. So welcome, Dilen, and I hope it's not going to be the last time that you're with us.
Thank you, Willie. I appreciate it, and it will definitely not be the last time.
I just want to touch on, if there is any questions that pop up during the webinar, you're welcome to put those questions in the Q&A. We will then answer the questions at the end of the webinar and email out the responses to everyone as well.
So before we start, can we just quickly have a look? I see that we are not as many as we were the last time. We're getting to the end of the year, so I think people are getting fatigued by all the webinars. But let's quickly run a poll and let's quickly see who we're talking to. Are we talking to trustees, to owners, managing agents, others, that we have an idea who is our audience today.
You can select multiple options if you fill various roles as well. Okay, just give it another minute. Everyone's filling out this poll super fast. Okay. I see we're mostly managing agents, and then owners and trustees also make up quite a large portion as well. So welcome, guys.
Thanks, guys. What we're going to discuss today is we're going to go through a compliance program and have a look at what it consists of. It is mainly a speech that I did at the National Association of Managing Agents conference in Stellenbosch a month or a month and a half ago. So we're going to just regurgitate the same information that we did there to the people that could attend, so that all of this information goes into the public domain, and we're also going to give away a very nice tool that can be used by schemes and by managing agents in making sure that they are compliant. So yeah, thanks for the opportunity to discuss compliance with you guys, and hopefully we will inspire you to become a compliance champion and build a sustainable compliance program of note. So compliance in general, one would think, is a very boring subject, However, it is the engine that makes schemes function in a sustainable fashion. And if there is no compliance, that scheme normally would collapse, and we would see that those schemes, there will be a loss of property values and so forth. So we'll deal with that a bit later on. So we're going to have a look at what is compliance management, why is it important, what are the challenges when building and maintaining a compliance management program. Going to look at conflicts of interest, which is quite an interesting subject, the modern approach to compliance management, the ultimate responsibility for compliance, so who carries that can, and should that can be passed on or the ball be passed on from one to the other. The influence of the contractual arrangement between the scheme and the managing agent. And this deals specifically with that passing of the ball. So can that ball be passed to the managing agent? We will have a look at the Property Practitioners Act, some out-of-the-box compliance solutions and I think one of those is one that Dilen actually did the amendment or the proposed amendment that he wrote in respect of the Act. Unfortunately, it wasn't accepted, but I don't want to tell the whole story. Dilen, you will tell us later on, and then we'll discuss NOCLAR, which is a concept that comes out of the auditing profession. And then how to build your compliance management program. So we're going to just have a look at a practical way of how to build that compliance program. And we will have a look at policies and procedures, and then we'll go through the compliance tool. So that's what we will try and achieve this morning. And we really hope that you guys will learn something from this. Okay, so what is compliance management? Compliance management is, in essence, the process of ensuring that the activities across an organization or an industry, so the activities of a body corporate, is in line with the laws, with the regulations and the rules applicable to those organizations or industries. So in the corporate world, they make use of process flows, policies and procedures, to make sure that compliance is then introduced. Auditing, internal and external auditing, is then used to make sure that it is followed. So one will have your internal audit processes and your external audit processes to ensure that those policies and procedures that have been put into your process flows are complied with. And then lastly, there is an enforcement portion of that as well, where authorities normally would make sure that if compliance is not followed, that it is enforced by way of some or other legislative tool, like a fine or something like that. So in general, it sounds like a tick box exercise. But it's far more than just a tick box exercise. Not that I'm saying that a tick box is not something that one would use. I mean, when we started Stratafin, I think that's how we did it. It was on a blank piece of paper with the tick box, and we would go through, this is complied with, this is complied with, before we would then look into a deal with a body corporate to make sure that we could collect that debt. So a tick box is a good start, but that is not where you want your compliance program to stay. One want to go further than that. So why is compliance management so important? Well, firstly, our laws are based on logic and morality. So the most important reason why compliance management is important, because it's the moral thing to do. It's the right thing. So in general, the laws would have built into them a process that makes sure that you follow the moral thing or the right thing or the logical thing. So it is the moral thing to do to be compliant, and schemes and managing agents must want to comply because that is the right thing to do, and people want to do the right thing. I know that we live in a country where it has become fashion almost not to comply with laws, where taxis drive on the side of roads and politicians do whatever they want, and at the end of the day don't care if it's the right thing or the wrong thing. It just doesn't matter. But I think from a point of view in respect of property, we want to do the right thing. We want to say we want to be moral, and we want to do the logical thing, and we want to make sure that schemes are run properly. Okay. It's also important because, and I think Dilen will speak about that a bit later on, there is a cost on non-compliance. So there can be a cost in respect of fines, but there can also be other costs, indirect costs, that is a heavy cost for a scheme to pay. So we will have a look at that as well. If you are in a very highly regulated industry, for example, in the you're a national credit, in terms of the National Credit Act, you're a credit provider, or you provide investment schemes to people, or you're part of the banking or insurance industry, then those industries are extremely highly regulated in respect of compliance. So these regulators ensure that people follow the rules and do things correctly. And if they don't do it, then they would get fined. But we're not there in the property industry as yet. We still need a lot to go to get to that point. The Property Practitioners Act, I would think, is a start in that direction, where we start becoming an industry that is regulated by a single regulatory authority, although CSOS is also there or thereabout in respect of sectional title schemes. In terms of the Property Practitioners Act, managing agents and their staff will now have to be registered, and we now know for a fact that they have to be registered. So I think Dilen can have a chat about that a bit. Dilen, what is your view on that?
Oh, Willie, so what I can tell you, it's a very interesting topic, and I think there's a lot of confusion around whether or not how this Property Practitioners Act is actually going to influence the industry of managing agents. And the most important part of the Property Practitioners Act, and I'm going to touch on it on a very high level now, because I think we'll debate it a bit more later on in this presentation, but it's a consumer-focused piece of legislation where they're trying to put the rights and the decision making back into the hands of this owner or of this body corporate, depending on the context of the situation. And then also it's an attempt to now professionalize the industry in a sense that we've got, as you've mentioned, this unified regulatory authority that's now going to prescribe codes of conduct to try and ensure that there is an industry standard and that is complied with.
Yeah. So there's also, I mean, I think we can have that discussion, but there's also now uncertainty as to where there are compliance issues where we thought that maybe under certain circumstances, the Property Practitioners Regulatory Authority would be able to put fines on managing agents. For example, if they appoint a service provider and there's a kickback, if I can use that word, paid. Don't know if that actually is what it says. I think that there is a debate regarding that still going on. What's your point of view in that?
Yeah, so I remember at the NAMA conference that there was a discussion with one of the individuals from the Property Practitioners Regulatory Authority, where they now seem to confirm that Section 58 does not apply to managing agents, in the sense that we are, as managing agents, in turn then entitled to encourage or oblige the use of a particular service provider. And in my view, when one considers the purpose of the act, in the sense that it's a consumer-focused act trying to protect the rights of a body corporate or the rights of a owner of a unit in a sectional title or a unit in an HOA, it doesn't make sense that they are now going to try and exclude that prohibition. So in my view, those types of things will still need to be debated, and I think we will have to then also have these decisions and utterances tested by courts at some point.
Yeah. So if we're not going to have a fine, for example, in terms of the Act, it does not mean that there is not a cost of non-compliance. There is still a cost, but those costs are then paid in intangibles. So those intangibles will be unhappy owners, the non-payment of levies, disruption of the scheme where people try and take over the scheme. I know that you were involved in an urgent application this week where people try to hijack the scheme as owners. Well, some of them were tenants as well, but where they try and hijack the scheme, where the scheme then collapses, where you will then eventually see the loss of property value, and then as a managing agent, you lose that scheme and you lose your income. So there is a cost still to be paid in non-compliance, even though that cost is not direct in the sense that it's a fine. But I would think that those costs of unhappy owners, the disruption of the schemes, the collapse of the schemes, those things are actually a higher price to pay than a 5,000 or 10,000 Rand fine. So I think, therefore, it is still important, even though we're not sure what the Act says and does the Act really regulate compliance or not compliance. There's still this cost to be paid, and I think it's important, therefore, that one carries on and be compliant and make sure that you are compliant.
Yeah, and just to add, I think there's two other important components how we will now pay for the cost of non-compliance. And the first is, as you've alluded to, the fines from governing bodies, where we deal with POPI, for example, where the information regulator is entitled to issue a fine to the maximum of 10 million Rand. So, I mean, in any event, no community scheme or managing agency that has the funds just to pay 10 million Rand towards a fine. So it's quite important that we comply with this legislation. And I think there's a misconception in the sense that individuals may think that the compliance with the Sectional Title Schemes Management Act or compliance with the Companies Act in itself is sufficient for compliance. But unfortunately, there's quite a plethora of legislation that we have to now comply with. And this is POPI, PIA, Promotion of Access to Information Act, Occupational Health and Safety Act, Labor Relations Act if we've got employees. So there's quite a lot of aspects and components to compliance that one has to consider. So firstly, as I mentioned, you can get a fine for non-compliance. And then also from our end and from a legal collections perspective, you also then see defective legal collections and the inability to actually collect what's due to the body corporate. I mean, I've advised numerous clients, how are you trying to now impose interest without an interest resolution? And that's clear, that's a compliance issue. We know the Act prescribes that if we want interest to be charged, we have to have an interest resolution. So in the absence of that, in the absence of compliance, then we also sit with a legal pickle where we actually struggle to now comply and enforce these levy debts from non-paying or errant owners.
Yeah, I mean, you're making mention of interest, but that's not the only thing. I mean,
Yeah.
When Stratafin assists body corporates and we actually take over the collection of these debts on behalf of the body corporate to get payment of the monies that was advanced to the body corporate, then we run into many obstacles where one can't show that there was actually a budget or there wasn't a quorum at the meeting where this budget was supposed to be accepted. I've seen meetings where voting takes place by saying, well, is there anybody against this? And that's the end of that. Nobody's against it. So, okay, it's a unanimous resolution. Well, that's not how a unanimous resolution works. So one needs to make sure that all these aspects of the Act is complied with, because, like you say, that stops you from collecting your debt. It also puts a longer period of time on a collection of a debt. I mean, you would know because this is what you guys do, but we see, for example, at the Randburg Magistrates Court, where if you don't have your regulating or prescribed management rule 25 letter, then that's they stop the default judgment. No default judgment is granted until you can show that you've given notice, even though there's case law that says it's not required in respect of the obtaining of a judgment. The magistrate still says, I want to see this. So you have to comply, otherwise you stall the collection of that debt, and the body corporate is then out of funds.
Yeah, that's exactly the case. You place a big obstacle in the legal collections process, if not rendering it futile. In some circumstances, the compliance is so bad that you're not going to get a judgment. And I mean, at the end of the day, some of these schemes actually really need this money, and they've budgeted for a lot of things that has to date not happened. So I don't think I can implore enough on that. Compliance is really important.
The problem with all of this is that it is not only the acts that you've mentioned. I mean, there are various other acts as well. And at some stage on Sectional Title Living South Africa, we had a poll that we were running, or a question that we were asking, what acts affect sectional title schemes? And there were so many that we didn't even think of. Like, for example, the Magistrates Court Act. I mean, because this is what is required and so forth. The Income Tax Act. Then the obvious ones like the CSOS Act, PAIA, Occupational Health and Safety Act when people work in a scheme. So Labor Relations Act, National Building Regulations. So there's so many things, and it actually requires from a managing agent to almost be a jack of all trades. And they must know about all these laws. And then it's not only the laws, it's even the common law, because we know that the common law of meetings are applicable to meetings. So what happens if there is a quorum? I mean, I was in a meeting the other day where there's 29 people that is required to be a quorum, and within 10 or 15 minutes of the meeting started, 4 or 5 people left the meeting. So suddenly, in terms of the common law of meetings, you don't have a quorum any longer. Can you make any legal decisions? So you need to understand that to be compliant with that. Otherwise, how are you going to be compliant of something that you don't know? So yes, that's why it's so important. That is why one needs to understand exactly what are the laws applicable and how they should be adhered to and what should be done.
Yeah, and the unfortunate reality that we're faced with is that CSOS is ready and waiting to invalidate decisions. It's been seen that there's almost, and I don't want to say it in so many words, but it seems to be that there's a bias towards managing agents and body corporate. So why give these types of forums, why give these errant tenants reasons to comply, or reasons to complain rather, as opposed to just complying with what needs to be complied?
Yeah, definitely. I mean, and you also mentioning there where CSOS has this attitude of trying to invalidate decisions. I mean, we all know now that you can't just put legal fees onto somebody's account, and you can't exceed the interest in terms of the in duplo rule. So you need to understand these things, and you need to understand how they are applicable, to apply them, to make sure that the scheme is compliant, to make sure that the scheme functions in a compliant fashion, and collect their levies, and in that way then be able to move forward and sustain and hopefully grow property values for owners.
Yeah.
I can just say, I mean, from our point of view, I don't think in the we started in 2014 with Stratafin. I don't think that we have seen any scheme, and we have analyzed hundreds of schemes in respect of compliance, because that's part of our process that we do when we do the funding for schemes. And we have not seen a scheme that is 100% compliant. And we have seen hundreds, if not thousands, of schemes documents, and we have not seen it. Right. What are the challenges in building a compliance management program? So the first challenge is to create a process flow. So you need to understand what the process is that needs to take place when you want to build this compliance management program. And then you need to have well-defined policies and procedures that you put in place, how to make sure that you follow this and what needs to be done. So the policies and the procedures actually lies at the heart of compliance management. So without that, there is no compliance management. Just want to have a look here. So in my mind, the biggest challenge is to monitor and make sure that you follow your policies and procedures. And that can be done in many, many ways. I mean, you can have your lists, your tick box, your spreadsheet, your emails, your software. And as the compliance landscape become more and more complex year by year, as more laws become applicable, it just becomes more and more difficult for managing agents, for trustees, and people in schemes to actually make sure that they are compliant. And luckily, we are seeing some out-of-the-box ways in how this will be resolved, and we'll have a chat about that as well. Okay. I think something that's also important is conflicts of interest.
Yeah,
So,
Willie, I agree with you. Conflicts of interest is quite an interesting thing, and I mean, practically speaking, and I don't think I need to elaborate on what a conflict of interest it is, but I mean, you've got an interest in a specific business transaction and an interest in a particular person getting that business transaction. That is seen as a conflict of interest. And what we need to understand with conflicts of interest and the common law approach to conflicts of interest is the moment that there is a conflict of interest that is present, one has to inform the individuals or the persons making the decision of this conflict. And then secondly, one has to refrain from participating in any way in this decision making. So let's say I've got a plumbing company on the side and I'm a trustee as well. I can't just give an invoice with a nice price to the trustees and tell them, I think this is a good person, without informing them that, listen, I've got an interest in this plumbing company, and then also me then refraining from making the decision. So if there's a conflict of interest, it doesn't prevent one from contracting with a scheme or contracting with a body corporate. The only simple answer to this is that one must declare that interest, and one must then also not participate in the decision making. And the moment that one does not do that, it opens ourselves up for a claim from any aggrieved party. So they can claim the profit that you may have made from this conflict of interest, or they can claim damages from you as a result of this conflict of interest that was not declared to them.
Yeah, and I think from a managing agent's point of view, I think the biggest area where there could be a possible conflict of interest is where a managing agent would receive a secret fee or a secret commission from a service provider for appointing that specific service provider to paint roofs, to build a wall, whatever the situation might be. The problem lies in the fact that this is secret. So one, to be compliant, one will have to follow the law. You will have to follow morality. That does not mean that because you are the managing agent, but you're now doing something else. So you are now managing the building of this wall. Then you can't charge a fee for that, which falls outside of your contract with the body corporate in respect of the normal management. So what you then will have to do is you will have to then state, I'm managing the building project. That does not form part of my normal contractual duties. And as such, I'm charging you 10% of the fee, or 5%, or 10,000 Rand, or whatever the fee is that you then agree. But you can't do so secretively. You have to disclose it. It has to be out in the open. And you need to make sure that you follow that policy and procedure to make sure that these things are open, that trustees are aware of it, that owners are aware of it, and everybody is happy with what you are charging for the service that you're rendering. Because managing agents are asked to do lots of things that does not form part of their normal contractual relationship with the body corporate in respect of the sending out of the statements and all those sort of things, which they don't charge for, which they actually rightly are entitled to charge for, but they must do so in an open and transparent way. And I think that is the compliant way.
Yeah, and the Property Practitioners Act also solidifies this position, where there's also a duty on a property practitioner to disclose the nature and extent of any conflict that it may have in a business transaction.
Yeah, definitely. So we've alluded to the modern approach. So the modern approach to compliance management is definitely now a software type of approach. And we are so lucky that we have quite a number of very innovative software packages that is now around that assist with the compliance process, like We Connect You, BCM Track, and MeetingPal. So those type of software packages makes it very easy for us to be compliant. I mean, MeetingPal, to run your meetings on there, to make sure that there is a quorum, that a quorum is maintained, that the vote is done correctly with voting cards, that one can go back and you can apportion the weight of the vote to that specific vote, and so forth. So those things make compliance much easier, and we can be lucky that we've got an innovative industry that actually does this. So in larger organizations like banks and so forth, they've got these large compliance departments that actually sits and goes through all the compliance regulations and the rules and so forth. But for a managing agent, that would be a huge cost factor to be able to do that. And luckily, we see that we're moving towards a solution that comes out of software that makes sure that these things that compliance can be adhered to. So I think the modern approach is definitely a software approach, where we then can make sure that that it's done. Alternatively, you will have to have a large department that must do it. Then the question is on who rests the ultimate responsibility for compliance management in the schemes. So in terms of section 3, 4, and 5 of the Sectional Title Schemes Management Act, the functions of the body corporate and the powers and additional powers of the body corporate is focused in section 3, 4, and 5, and that falls on owners, and then that is delegated in terms of section 7 to the trustees or the scheme executives. So they then must exercise the functions and the powers and the additional powers afforded to them in section 3, 4, and 5, or afforded to owners, but they then do that. And the trustees must do so in accordance with prescribed management rules. And the prescribed management rules, in essence, one would say, is the standard operating procedures of a scheme. So that's where you would start. So one need to have a full understanding of the prescribed management rules, because that is where you start once you build or when you build your compliance program, to make sure that you follow each and every rule as it was accepted or tabled in law.
Yeah, and I just want to mention that in terms of the Company Act, for all of our HOA directors in here, that they have a similar position, and that your fiduciary relationship towards the HOA in effect also makes one responsible for complying or to ensure that your scheme is in fact compliant.
Yeah. What's also interesting, Dilen, I would think, is that the Act is silent on the functions and the duties and the responsibilities of a managing agent. So there's absolutely nothing that's stated in the Act that says these are the duties of a managing agent. So it merely states that the trustees have the right to appoint an agent to perform specific financial services, secretarial services, administrative services, or other services. So clearly, from the reading of the Act, the responsibility for compliance falls on the trustees. They must make sure that they understand what compliance is required and that the managing agent complies with that. And I think, and something that we will discuss just now afterwards, but I think to introduce it, and I think that's where the problem lies. And I've seen this on Sectional Title Living South Africa many times as well, where owners come onto the platform and say, but I've asked the managing agent for this, or I've asked the managing agent to show me that, or to do this or to do that. And then the managing agent just says, well, it is the trustees that must do so. So the managing agent is then slow to actually assist the owner, because at the end of the day, the trustees tell the managing agents what to do. And if they don't follow what the trustee says, then they are in a situation where their contract can be terminated. And it creates a problem for them as well. However, they are actually there to service or serve the owners, but then report to the trustee. So in my mind, there's a bit of a problem in that respect. I think there's something that needs to be done in respect of that in the Act. But as it stands at the moment, I mean, the trustees ultimately remain responsible for that, and to make sure that compliance is followed. So the nature of the contractual arrangement between the body corporate and the managing agent has obviously an effect on compliance as well. In terms of the old Act, the Act specifically referred to the relationship of master and servant. As I said, I mean, the body corporate is the master, the trustee, the managing agent is the servant, and they must comply with those instructions, legal instructions that were given to them. It is a very similar relationship to that of an employer-employee, although an employer-employee relationship is a relationship between a natural person or a corporate or a business and a natural person. So at the end of the day, your employee is a natural person, where in a master and servant relationship, the servant does not necessarily have to be a natural person. It can be a company that is the managing agent. But it's a very similar type of relationship as employer-employee relationship, where the employer tells an employee what to do.
Yeah, no, Willie, I agree with you. And if we specifically add to that, and in particular with the Property Practitioners Act, what we can see, what is happening is that we're moving towards, as I mentioned, to professionalize this industry, because we've had instances, and there's a lot of instances where the trustees would point the finger to the managing agent, and the managing agent puts his hands up and say, I only act on instructions of the trustees. And then we in this limbo, almost legal-like limbo, where no one actually now or everyone's trying to pass the buck, and no one wants to take accountability for what's happening. And this is what I appreciate about the Property Practitioners Act, is that we're trying to now professionalize this industry. We've got a curriculum, we've got the NQF4, NQF5s. The Property Practitioners Regulatory Authority is also in the process of negotiating with various stakeholders so that we can have industry-specific expertise or qualifications that one can now get. So, for example, you can go to managing agent school, for lack of a better word, where you would then now get well equipped with all of the particular aspects that one would then have to deal with in a instance where you have to be a managing agent. And it's also it's similar to an attorney-client relationship. I mean, ultimately, we are advancing the interests of our client, and we are acting on the instructions of our client. But where there is a component of professional negligence, then the liability seems, we almost seem to pierce this veil of only acting on instructions. And you can see that in the Property Practitioners Act as well. There is a requirement that the minister may prescribe a specific indemnity insurance, and the field and ambit of the indemnity insurance that one would have to take out as a property practitioner. And I mean, the whole principle of indemnity insurance is to protect a scheme or to protect a person against loss as a result of professional negligence. So there we can see the lines are again becoming a bit blurred as to who is now responsible for compliance. But I mean, when it is a thing where we are giving advice as a managing agent, and as a result of our advice that we gave, there's now some or other loss or damage that has ensued, then we can actually see where this veil will be pierced, and where the managing agent will actually be held accountable for compliance.
Yeah, I think you touch on a very, very important aspect. I mean, where we move away from this employer-employee relationship to the professional relationship in terms of the Property Practitioners Act. So you spot on, because at the end of the day, if you are the professional, then you have to make sure that you follow compliance regulations and laws and so forth. So that is extremely important, and then you can't use that as your excuse to say, well, the trustee said to me I must put the legal fees on, even though I'm aware that it shouldn't go on. There should be on your there should be an obligation on you as the managing agent to ensure that the rules are followed, that the process and procedures and the rules are exactly followed in respect of the levying of the levies, putting the legal fees on and so forth. So absolutely correct where we're moving towards, but unfortunately we're not there yet. So in my mind, I believe that there is a different way in the interim that owners, until such a time as that is solidified in legislation, I think that owners can place a restriction on trustees to not dismiss the managing agent unless it goes to an owners meeting, so a special general meeting or AGM, so forth. By doing so, the managing agent then gets the assurance that if they act correctly and the trustees are not happy with the way they act, that they have the chance at an AGM to say, but we are being dismissed because we didn't want to do A, B, C, and D, and A, B, C, and D is against the law. You can't do this because this is what the rule says, or this is what this act says. And now the trustees want to dismiss us, and they're not happy with us because we're doing the right thing. And then owners will say, no, we're not going to allow the trustees to do so. So in my mind, I think if one can use Section 7 and as owners to place a restriction on the dismissal of the managing agent, then we've already strengthened the oversight of compliance by making sure that the managing agent can do so in this interim period where we are moving from an employee-employer relationship to that of a professional, where the managing agent is the professional and has to comply. He's got no choice, because if you don't comply, you will be fined and you will be penalized and you will have a problem if you don't comply.
Yeah, no, I completely agree with you, Billy, but I'm not going to rant away, but yeah, there's still a lot of uncertainty, and we've not had a lot of guidance from the Property Practitioners Regulatory Authority. So we'll unfortunately have to wait and see when they decide to give this oversight and regulation, so that we can, all of us actually can be in a better position to see what the trustees can and can't do, and what the managing agents can and can't do within the confines of when there's loss, who is actually now going to be accountable. So yeah, I think we've touched a lot about the Property Practitioners Act, but just again, in high level, this is a consumer-focused piece of legislation trying to professionalize the industry, and secondly, trying to put the decision-making back into the hands of the owners and or the body corporate, depending on the relationship that the property practitioner has with the client. So what we need to understand, and it's I'm just going to touch on it a bit, is the prohibition on rendering services or encouraging or obliging the use of a particular service provider. So as a property practitioner, we must really be wary of encouraging or obliging the use of anyone. We can't just say, listen, we've got this plumbing oak, you can use them. So we must make sure that we in a sense, make it their decision, put the decision back in their hands. So there's no donuts if you make the decision, and we won't reply to your emails for 4 days if you don't. So we need to just steer away from that, as we can see that the Property Practitioners Act actually wants us to steer away from that. And ultimately, when we look at the inclusion of indemnity insurance into the Property Practitioners Act, and indemnity insurance into the realm of a property practitioner, or into the realm of a managing agent, we need to understand that there is this component of professional negligence, and that a managing agent will ultimately also bear the responsibility for ensuring compliance by their clients.
Definitely. We've also looked at a couple of out-of-the-box solutions to make compliance management more, or to ensure compliance management takes place. And I mean, stuff that we looked at was, for example, legislative amendments. I know that you proposed a change to Section 15B3 of the Act to make sure that a scheme must also state when that certificate is issued that it's compliant in all aspects. So, for example, that nobody has extended on the common property, and the sectional schemes plans have not been amended. So therefore, levies are levied incorrectly because the PQs are not correctly any longer. So you've made that suggestion. Unfortunately, I see that it's gone to the president and it's not in there.
Yeah, so what I can say, and it's something, it's a frustration that I've been dealing with as well, when trying to now resolve a matter between a community scheme and its members, where a new owner now buys a property, and we then now try and enforce the registered unit, or the actual how the building should look on this new owner, and then they turn around and say, listen, I bought it like this. It's the other person's problem. And I mean, ultimately, the purpose of the suggested or proposed amendment that I gave to them is that there is the certification process, so that before transfer can in fact occur, that the building and the unit is actually within the confines of the registered plans. So that was the amendment. But as you mentioned, no input was given, or it was seen as irrelevant to the industry. I know no one here probably suffers from people extending units and consolidating garages, so it's definitely not something that's a headache for all of us. But be that as it may, it seems it's not going to go to the president's attention, unfortunately.
Yeah, and then we've had mandatory compliance reporting by schemes. So I think that's something that we're also saying that should take place. So schemes should actually be forced to do compliance reporting to CISOs, for example, that says we have complied with the following for this year. And the trustees must then be held accountable for that. So I think that is important as well. And then, like we said, where we're moving to professionalizing the industry, but it has not become a profession as yet. one can put in place a contract with your managing agent that places a professional, or places him in the position of a professional, where you say you have to make sure that compliance is followed and so forth. And in that aspect, then it will become a contractual duty on the managing agent to ensure that compliance has taken place. And one would actually think that that is the better place where compliance enforcement, or compliance, where compliance should take place, must lie, because managing agents in general have a far greater idea of what is required by the laws than trustees that are changed on a yearly basis and have no knowledge in respect of sectional title law and so forth. Then the other suggestion was the NOCLAR type audits. So we are seeing it in the profession that when audits are being done, that auditors are saying that an AGM was not held within time periods, and as such, there's no compliance with the Sectional Title Schemes Act. So NOCLAR is definitely also something that needs to take place. So NOCLAR is just a non-compliance with laws and regulations, and in the audit profession, it is required of auditors when they do an audit in terms of these international ethics standards that they must say you have not complied with a law, a particular law. So I think it's time that these type of laws become part of the sectional title industry as well, to ensure that on all audits there is a compliance audit done as well, to make sure that schemes are acting in a compliant manner. Then we're getting to building your compliance management process. So I've just quickly, and we're running out of time again. So we've been talking so nicely, and now I'm running out of time on the practical stuff. But building your compliance management process, you start out that says, what do we want? We compliant budget process. So we would say, okay, the trustees need to make a decision to prepare a budget. They must call a trustees meeting. They must make previous years management accounts available to them so they can go through that. So we would build the story, what needs to happen. So we'll step by step by step exactly what needs to be done. So then you've written the story down. So you've dealt with how to prepare, how the meeting is going to take place. What are we going to do? What are we going to what are we going to utilize to make sure that the budget is correct? So we're going to do a spreadsheet. We're going to apply the participation quotas. We're going to amortize it over the period of the repayback and so forth. So you will make use of some or other tool to make sure that it's done correctly. Then the trustees to the managing agent. Managing agent, you must do A, B, C, and D, and then eventually up to your AGM. So you'll write the whole story down, and that's where you start. Then you would go and you would put that into a process flow. So Cora, if you can just go to the process flow for us. So you would then build yourself a process flow. So we in Stratafin make use of some fancy software that we built our process flows in, but you can just use a normal Word document with your squares and your triangles and whatever. So you put your process flow in there, and you will say notice of trustees meeting. Okay, then to do a trustees meeting, we're going to give notice. How's that notice? How is it going to be kept? How do we know that notice was given to everybody? So you will do all of that. So all your the underlying steps that will be followed. You're going to put that in there. You're going to have your processes and your standard operating procedures that you write down. And every time that you do this, you do a budget, you follow the same process exactly as you have outlined it once and for all. And by doing so, you have now built yourself a compliance program. And every step that you do, raising of levies, disputes, appointment of a service provider, every one of those, you will build your story and you will then do your process flow. And underneath that, what needs to exactly happen in that specific step that you need to do. And that is the way that business in general, large business, would build their process flows and will make sure that they are compliant and that they follow the correct compliance process and procedures. So you'll see, I mean, obviously we're going to send this out and you'll see how we've built this up to where budget is implemented and it was done in a compliant fashion. And as Dilen said earlier on, if you followed this process to have a compliant budget and a compliant levy process to levy a levy, then you know that when you institute legal action at the end of the day, you will be able to recover that because you have followed the rules in the way that the rules needs to be followed for a court to actually approve that judgment and say, yes, we can grant a judgment because you have followed the rules. You have not left out certain steps. It was owners that decided this is the budget. It was not the trustees that raised the budget by 25%. It was done by the owners at an owners meeting. There was a quorum. There was a proper decision taken. Was a majority decision. Notice was given to owners when it will become applicable, and they have implemented it on the levy statements from that specific date. And then you will be able to recover that, for example.
Yeah,
Okay,
and I must say, sorry, Willie,
no problem.
and just from a practical perspective, if you want to avoid mistakes, if you want to avoid falling foul and falling short from being compliant, it's the easiest to write it out. I always say, write it out from step 1 to step 10. And when you get to step 10 and you've done it from 1 to 10, there is not going to be a problem. So the problem comes in when owners or trustees or managing agents think they know what's going on and how to conduct themselves, as opposed to now trying to get an SOP or trying to do a process flow and actually just making sure that it's efficient and effective. Because I mean, it's going to take time. It's definitely quite a task to get all of these process flows and standard operating procedures in place. But the moment that it's in place, it's going to be much of a muchness, and it's going to be business as usual. So it's to me, it's very important that you actually do these things so that we can avoid these common pitfalls that do occur in these circumstances.
And as a managing agent, if you do this, you will stand out from the bunch. You will be different because you will know that your clients will know that what you do is compliant and you do it in exactly the correct fashion, and they will understand that you follow the law. And although there will be an initial cost in respect of staff's time and effort that has to go into this, it will make compliance much easier in the long run. And in the long run, it will make you money because people will come to your managing agency and say, manage us, because they understand that you're doing things right. They understand that you know what the process flows are. You know what the standard operating procedure of an AGM is. You understand to do things correctly. So at the end, I think it is important to build this and to make sure that one follows this always, and it becomes part of your DNA. This is how you operate, because if that's how you operate, then your schemes will be compliant and they will do well, and you will be able to recover if there's a problem. Looking at from your point of view and from our point of view, where we need to recover. Then what we've done is we've built you a little compliance calculator as well. We did say that we're going to make that available on our website as a free resource as well. So the compliance calculator is going to ask you certain questions in those blue blocks, your SS number, when your financial year end is, what is the first day of your new financial year, your number of trustees, how many sections are there, what is the insurance value, when was it last done, and so forth. So it will ask you a couple of questions, and that will then populate a calendar that will tell you when you need to have your next AGM, when trustees need to have a meeting, when they need to start with their budgeting process to make sure that they do it in time. So it gives you an annual year planner that has got various aspects on there. It will tell you then you need to do an insurance valuation at this stage again. You need to do A, B, and C by this date. So there's an annual year planner, and then it gives you a month-by-month year planner. Open as anyone, so we can then see, check your management statements, monthly levy payment, you need to respond to that, and so forth. So it gives you a day-by-day compliance calendar to make sure that you follow the rules and do all the things that is required. And we hope this is going to make it a bit easier so that you don't forget some things. I know that you guys are got lots of stuff to do and don't always remember all the stuff, but we've tried to build in as much as possible. And go onto the website and have a look at that and see if that can assist you guys. Thanks, Dylan. I really appreciate it. It was lekker talking to you and to everybody today. And I really hope that you guys can make use of this. So we will send out all the slides, so you can have a look at how we are doing the process flows and the standard operating procedures, understand how that is done so that you can start building those and making sure that you do the same thing over and over correctly the whole time.
Yeah, Willie, just from my side, I just want to say thank you as well for the opportunity. It's wonderful to be part of this platform. I've always enjoyed these webinars that you guys present, and I think it's very informative and very relevant. And I think there's a lot of misconceptions and misunderstandings in the industry, and I can see that this webinar is actually focused on addressing these misunderstandings and misconceptions. So yeah, thank you, and thank you for everyone present as well. I really appreciate it. It's role players and stakeholders like you that make the industry a better place, and that makes me want to get out of bed in the morning and come and fight for your levy. So thank you very much for taking the time to listen to my and Willie's boring voices. I know it's always interesting when it's the 1st of December to chat about compliance and this compliance mountain that we have to now undertake. But yeah, thank you everyone for attending, and thank you, Willie.
Just to
Thanks,
everyone,
guys.
sorry, just to everyone that has submitted questions, I have taken note of all the questions, and as mentioned in the beginning of the webinar, we will be emailing out the individual answers to everyone as well when we send out the email with the recording of the webinar and the presentation, as well as the compliance calendar.
Okay, so this is our last webinar for the year. So we'll start next year again. We're also going to continue with the Let's Get Physicals with Zerlinda and the other people that are involved. So I think the next one is in Durban. Am I right, Cara? So we're having a Let's Get Physical in February. And there we will physically see each other and we can have a chat about all the different aspects and things that we are talking about. And then I think April, is it April or May that we've got the Let's Get April, we've got the Let's in Johannesburg. So then we'll have the Let's Get Physical here as well. And guys, look out for that. And we hope we see you there.